doesn't matter whether you are taking on your first employee or whether you have 100 employees. The things that you need to have in place as a business are the same. So I'm going to just talk through pre-employment steps to take to make sure that you're legally compliant, some key documents and tips on what to include, and then some processes to implement, which will just assist you with the employee journey from start to finish. So first of all, if we look at pre-employment steps, so hopefully you have either made the decision that you're ready to recruit, or you're certainly thinking, in the coming months that it's time to recruit, or maybe you have your first sort of employee or two on board already. But once you have really made that decision that it's time to take on some staff, you need to decide, first of all, what is their employment status? Because they could be an employee, and there are many variations of employees. They might be full-time, part-time, permanent, fixed term. I'll be talking about these in more detail in a second. They might be a worker, which is a little bit different to an employee, sometimes called 0 hours or casual or bank worker, or they might be self-employed, so a consultant. So it's really important from the outset that you're determining, who is it that you are recruiting. I can hear the sound is cutting out. Is it bad for everybody?
Yeah, mine's fine.
Okay, so first of all, the easiest, I guess, of all of the groups that I just mentioned is your permanent employee. So this is somebody that you're employing, and they're going to have full employment rights, and that means that there's a mutual obligation from you as the employer and from them as the employee. So with this type of employee, it's really important that they have an employment contract, and I'm going to go through with you all of the different things that you need to have in place in that contract. The other group that I mentioned is a fixed term employee. And a fixed term employee is essentially the same as an employee, but where the contract is only expected to last for a certain amount of time. So you might take somebody on for 3 months or 6 months, maybe to give you sort of a bit of extra sort of boost with your employment for a period of time, or it might be because there's a project that you have on. And these contracts will normally just come to an automatic end at the end of the term, although it is possible to have a clause in these contracts whereby you can extend the term, or indeed you can end the term a little bit earlier if needs be. But the important thing to recognise with a fixed term employee is that they are an employee. They have all of the same employment rights as your permanent team, and they shouldn't be treated less favourably because of their fixed term status. So they should have the same pay and conditions as permanent staff and the same equivalent benefits. And you should really be also making them aware if other vacancies become available in the organisation. They do have protection against unfavourable treatment. And it's really important that if you have a contract clause that says it comes to an automatic end, that you make sure that you're on top of, when is that going to happen? So you're having those conversations before it comes to an end. And then you've got worker. So a worker is not an employee, but they are on your payroll. So they are somebody that you would typically use during busier periods, maybe seasonal workers, or if you're in hospitality and catering, for example, and you just need sort of extra pair of hands for a particular event, that's when you're likely to use your casual worker. So the key with a casual worker is that there's commonly no obligation for you to offer them any particular set hours of work. There's no obligation on the worker to accept that work. So if you offer them a shift, they might say, well, no, thank you, I'm busy on that day. Really useful, as I said, where work demands fluctuate. And Whether or not an individual is an employee or a worker or neither is going to depend really on what is the nature of the relationship in reality. So you've probably seen that 0 hours gets a lot of bad press. And the reason for that is where businesses have used casual workers or 0 hours, where really they're an employee and they work every week. Maybe they're variable hours, but they've been working for the same employer week in, week out for many, many weeks, many months, sometimes many years. And that's when they're being used inappropriately. And then you get all the sort of bad press around them because the individual is not getting all of their employment rights that they would be entitled to. So I would just caution that it really doesn't matter what you write on a piece of paper, because if there were ever to be a dispute, a court of law would determine what is the reality of the relationship. But workers, although there's a lot of bad press about 0 hours, they can be really useful if used appropriately. And then we come on to self-employed. Again, this is another one where often people use self-employed status inappropriately. It can be great to have a consultant to come on board, maybe where you need a particular specialism for a particular period of time. But there's a bit of a test, I suppose, if you're determining whether someone is self-employed. And that would be where somebody is genuinely in business for themselves, where they're responsible for the success or failure of that business, and where they can make a profit or they can make a loss. Crucially, they will invoice you for payment rather than being on your payroll. That's a real big determining factor in whether or not somebody is genuinely self-employed. They can decide what work they're going to do and when and where they're going to do it. And quite often they can also hire somebody else to carry out work on their behalf. So if you are looking to take on somebody on a sort of self-employed consultancy basis, it's very important to consider things like that, whether you're going to allow them to use their team or whether they have to carry the work out in person. Also considerations like, if you're not happy with the standard of the work, will they have to fix unsatisfactory work in their own time? Is work a fixed price maybe, rather than it being an hourly rate? Commonly there'll be a daily rate. And do they use their own equipment or their own tools? Do they have their own sort of email address, or have you placed them on your sort of IT systems? And can they work for more than one client? And if the answer is, well, no, they use your equipment and you control their working hours, you are, for all intents and purposes, the employer, then that is what is likely to be a decision in the court, in the tribunal, if it were all to go wrong and somebody were to bring a claim. So that's just a little bit of an overview of the different types of working relationships that you might have. But today we're going to focus very much on employees. So once you've determined what type of person that you need to bring on board, you're going to offer them employment. So here is a really good idea to offer employment formally in a letter, and for that job offer to be conditional. And what that means is you would set out in the job offer what it is that you're offering, but you would make it conditional on certain things. For example, if you're intending to seek references, then you would say in the letter that, this offer of employment is conditional upon us receiving two satisfactory references. It may be that you need them to have a particular qualification or professional membership. So you would need to sort of state that in the offer letter, that it's conditional on that. And maybe in certain businesses, you might need them to have a satisfactory disclosure and barring service check, to check their criminal history, or you might need credit checks, for example. If it's a role where they're going to have a lot of financial responsibility, it can be quite common to require a credit check. But I would just caveat that with, making sure that it's appropriate. So you put things in the offer as being conditional if you don't really need them. And you don't actually have to seek references, for example, but it is a really good idea to get a reference on somebody that you're going to have a long-term working relationship with. And then the next important thing before they join you is to check that they have the right to work in the UK. This is really important. You have to make sure that you check and hold copies of right to work checks. And you also have to make sure that you see the original document and that you verify it in person. If you put into your search engine right to work check gov, it would give you loads of government guidance, and in that you find two lists. You would find list A and list B. The easiest document is always a UK passport, because that's the only document you would need. But if somebody doesn't have that, there's a whole list of documents that you can use instead. Alternatively, there is also the Home Office online right to work checking service, which you can use to check that they have the right to work in the UK. It's a really good question there. Do passports have to be in date? Yes, they do, because you would need, if it's a British passport, then you could take a view that, you're happy that they're a British citizen. If it was a different type of passport, I would definitely want it to be in date. And really, ideally, you would be looking for all documents to be in date. But the key is what you're actually checking is, do they have the right to work in the UK? So if it's a UK passport that has expired, well, that doesn't mean that they're no longer a UK citizen. So for the purpose that you're using it, that would still be a suitable document. The other thing is to note, obviously, that since Brexit, EU nationals entering the UK also need to have permission, such as a sponsor license, which is quite a complex process. And again, if you search into that, if you're thinking of employing somebody who is an EU national, you'll find loads of information. And I've just put a little link at the bottom of this slide that will give you sort of extra guidance on it. In terms of, do you have to check regularly? No, you have to check on commencement of employment. But the really important thing is you have to check before they join you. There's something called a statutory excuse. And it means that if you check the documents on the first day, you lose the statutory excuse because you've already employed somebody who doesn't have the right to work in the UK. And the penalties for employing somebody who you didn't have the right to work in the UK are quite severe. They're very heavy fines. You can also be liable to prosecution. In very serious cases, or even you could have a legal working closure notice placed on your business. But it's a tricky one because you have to check before they start with you, but it wouldn't be appropriate to just check with everybody at recruitment stage, because under GDPR, you shouldn't be processing information on an individual if you don't need to process that information. So you only need to process it after you've made an offer, but you can't wait until their first day. So somewhere in between, you need to be asking them to come in, because remember, you have to check in person to show you the original documents for you to check them and take a copy and keep a record. Okay, so now we're going to move on to key employment documents. And we're going to talk about the contract of employment. So we typically will call it a contract, but actually the legal term is the written statement of terms and conditions of employment, so the written particulars. And you have to, under the Employment Act, you have to make sure that you are providing the written statement at the beginning of employment. Years ago, we used to be able to provide it within the first 2 months, but that's all changed. It's now a day one right. And it is still a day one right that many businesses fall foul of. So it's really important that ideally before somebody even joins you, because they should have the opportunity to see the full terms before they come on board, but certainly no later than their first day, you need to be providing them with their employment contract. And although today's session is focusing on employees, I should just note that when they changed the law to make it a day one right, they also introduced it as a right for workers, for 0-hour workers and casual workers. So you need to make sure that there's also a written agreement in place for that category of worker as well. They also changed the things that you need to have in the written particulars. This all happened in April 2000. So some things you don't have to have in the main document, and you can deliver them in instalments. So we'll talk about the difference now in terms of what has to be in the contract and what can you provide in writing after employment. In another way. So the principal statement is your main document. So you're going to have the parties, so the name of the business, and really important to write the name of the business as it appears, for example, on Companies House, so in full, and you're going to have the name of the employee or the worker. I would usually also include their home address. So right at the beginning of a contract, it would say who the parties are to the agreement. You would put the date of commencement of employment, so their start date. But you would also need to put the date when continuous employment began. And they're not always the same, because sometimes you will offer maybe a promotion, or the contract terms will be varied, and then you might offer a new contract, but the continuous employment rights will have begun on the date when they first started with you. So if it is a new contract, you would say that the terms of employment under this agreement started on whatever date it's being issued. However, the continuous employment began on, which would be an earlier date. It's also something you would use if you were to acquire another business, and maybe you would acquire a contract that involves 2P, and you have employees that transfer over to you, where their employment with a previous employer would continue with yourselves. So in those circumstances as well, you would be stating a different date when their longer term employment began. It's really important that you set out not just what their pay will be, but the method of calculating their pay. So is it hourly? Is it daily? Is it monthly, weekly? So you need to be really clear about what the remuneration is and how often it's going to be paid. So as I said, weekly or monthly. So in terms of, sorry, I'm just seeing a question flash up about where can startups get support for employee contracts and document creation. Business Wales offer support, and sometimes if you speak to your relationship manager, it's something that a recruitment readiness type work package might be supported under the AGP, but your relationship manager is absolutely your first port to call for anything when you're looking for a little bit of extra support. And then there are obviously companies like my own where we offer commercial services to businesses for exactly this sort of work. So you would be saying the intervals at which remuneration is paid, but not just monthly. For example, you would say on or around the last day of the month, or on or around the 19th, or the last working day, or the last Friday of each month. So it's really important to be very clear in your agreement as to the intervals really specifically. You need to put in the hours of work. I mean, normally you would have a start time and an end time, but it is possible as well to have variable hours, in which case it might be based on a rota that you give every week, or it might be something that you agree monthly. But in the principal statement, you would need to be saying what the hours are going to be or how they're going to be arranged. You also need to put in the principal statement holiday, so holiday entitlement, but also holiday pay. So with holiday entitlement, if it is somebody who is part-time, you would always put in what their entitlement is, but then you would add what the full-time equivalent is, so that you know what it's based on, because part-time employees are not allowed to be treated less favourably than full-time. It should literally be a pro rata calculation. But for a full-time employee, the basic statutory minimum is 28 days a year, and that can include any bank holidays. So if a bank holiday then falls on a normal working day, then it would be deducted as a taken holiday. Also important to note that holiday pay, if you are a business that pays commission, or you're a business where an employee routinely works overtime, those things become part of their normal remuneration. So when they take a holiday, you need to not pay them just at their basic pay. You need to do a calculation of their average pay over the preceding 52-week period, and that will tell you how much they actually get paid when they take a holiday, because otherwise they could really find that they are out of pocket every time they take leave. That's something that case law changed the law on a few years ago. You also need to include things like the terms relating to sickness and injury. Are you going to pay them statutory sick pay if they're eligible, or are you going to offer them an enhanced payment to cover them during periods of incapacity? Important that you put in there any terms relating to other paid leave. So, for example, are you going to offer enhanced pay for maternity leave or paternity leave? There is now statutory payments, for example, that also apply to bereavement leave for parents. All of these things have to be stated in the principal statement, along with any other benefits. So even if they are non-contractual benefits, you should be listing them in the contract and saying that they're non-contractual, and that you can vary them or get rid of them altogether at any time. And that could be anything from non-contractual benefits, could be something like an employee assistance program, or subsidised gym membership. I mean, the list of benefits is huge. Bonus schemes would also go in the contract generally. Now, you can have a discretionary bonus. You can still write a clause in the contract to say that bonuses are discretionary, but just be careful, because if you always pay a bonus every December, and you do that for a really long period of time, and it's always the same amount, by custom and practice, you might actually be changing your contract so that it becomes contractual. So it's always a good idea to make sure that you're constantly reviewing any bonus schemes if they're discretionary, to make sure that you're not just paying the same thing on the same criteria year in and year out. If you do offer a discretionary bonus, you do need to put it in the contract, because it is a form of benefit. But as you grow and you evolve, what you're able to do is vary your contract. And if you're going to offer more favourable terms, then it's really easy, because you could just do a side letter to sit alongside the contract, or if you're making more substantial changes, then you might reissue the contract altogether. But absolutely, as you grow, as you evolve, you know, your benefits package is going to be changing all of the time. You need to say in the principal statement the notice period. So is it a week? Is it a month, 3 months, 6 months for very senior roles, for example? But a note on notice periods, the statutory minimum notice that an employee has to give you in the first month of employment is no notice at all. And then after the first month is a week. And it never increases from a statutory perspective, but you might have a longer notice period that is in the contract that they are contracting into. The flip side, the amount of notice that you as the employer have to give the employee, again, in the first month, there's no requirement for notice. And then after the first month of employment, up to the first 2 years of employment, you have to give at least a week's notice. And then thereafter, so once they've hit the 2-year mark, every single year it is increased by 1 week up to a maximum of 12 weeks after 12 years service. And that's where it stops. And you can't offer less than that. So you can't contract out of statutory rights. But it is possible to have a contractual notice period that is in excess of that. So quite often in a probationary period, you might have a shorter notice period. And then once somebody successfully passed probation, then it might go from maybe a week in probation to a month. And you know, that's what it might stay at until you get over the 4 years service and you have to start adding an extra week on as the employer. The employees doesn't increase. So it would only be from the perspective if you were giving notice to the employee. You need to keep an eye on statutory notice. If it were gross misconduct, then that's summary dismissal, no notice at all. So you would only be able to go down that route if you followed a fair procedure. So you would have to carry out investigation. You would have to invite the employee to a formal meeting so that they, you know, can have the allegations put to them and they can respond. They have the right to be accompanied by a trade union official or indeed by a fellow worker. And only after a fair hearing would you be able to make the decision to dismiss for gross misconduct. But if you did find that it was something that was so serious that they were to be dismissed and it was gross misconduct, then yes, the notice doesn't apply. It's summary dismissal. I said about temporary contracts earlier. So if it is a fixed term temporary employee, then you would put in the statement that you know, what the length of employment is. And it's a really good idea to put a probationary period in. Probationary periods don't actually have any legal definition, but they are a really good way of setting out the expectation from a contractual point of view that the first maybe 3 months or 6 months is probationary, where an employee's performance is going to be really continuously monitored quite closely, and where at the end of that period you're going to make a decision as to suitability for ongoing employment. That should be stated in the contract if you're operating a probationary period. Also a good idea to put in your clauses that you reserve the right to extend a probation by a fixed amount of time. So if, for example, the probationary period is 6 months, then you might include that you reserve the right to extend it by a further 3 months. Equally, really good idea to say that probation isn't deemed to be successfully passed until the employee receives written notification. I say that with caution. That doesn't mean that somebody who had a 6-month probation and has been with you for 9 months, you can suddenly say, oh, you haven't passed probation after all. So you have to always act reasonably. But if, for example, there was a reason why you were unable to complete the probation review right on the date and it went over by maybe a few days or more, then you know, you're relying on the fact that your contract says you don't automatically pass. We have to have the formal review. So one question that I see you're getting asked regularly is how probation periods work with continuous employment. So a role change, and do you need from the outset within the contract, what happens if they don't pass probation for the new role? Yes, you do. Really good question, and something that is really important that you think about. If you are putting in place a new probationary period and somebody has already got at least 2 years continuous employment with you, and when they go into that new role, you can't just fail their probation at the end of it. You would have an obligation to be looking, can they go back to their original responsibilities, or is there a suitable alternative within the business that they could move into? And really, you are dismissing them for poor performance effectively. So it's really important that if somebody is just going into a new role, and if you're introducing a probationary period, that you are monitoring it throughout, and really following a bit of a formal capability procedure alongside if you think that they're not performing and you're likely to have to dismiss them at the end of it, because as I said, probationary periods don't really have any legal definition, and they're not ideal in a new role, because what do you do with somebody if they fail? Place of work needs to be in the principal statement, and whether or not the employee is required to work abroad for a continuous period of a month. Because if an employee is going to be working abroad for a continuous period of a month or more, then you will have a whole load of new implications in terms of the host company's employment rights. And if they are more attractive than the UK rights, then you would need to be potentially ensuring that they are not falling below those rights. There are also tax implications, although I can't advise on tax, but that is something that you would have to get advice on sort of from your accountant or your tax advisor. Place of work is changing because of the pandemic. We're finding that home working or hybrid arrangements are more and more common. So I would advise that you're making that clear in the contract, that whether it's partially office-based, partially home-based, fully home-based, and if it is, little extra things to think about, like do they have the right to work from home, under their mortgage or their lease, their tenancy agreement. Do they have to make sure that they've got suitable facilities at home? Are you going to contribute anything towards those facilities, such as utility bills? Do you want to have the right of access to check things like health and safety, or if you need to carry out repairs or retrieve your equipment? What security measures do they need to have at home? Do they need to have a locked cabinet where they can keep, all of any work documents? Do they have to make sure that only they have access to their work computer, that it can't be used for sort of wider family members, that if they walk away from their computer for any amount of time, that they have to make sure that it's password protected and that they lock their computer? So there's just so many considerations with place of work if they're to be a home worker for a routine amount of time. Something else that is a new requirement in the principal statement is training. So you should have a clause in there that states whether or not you are going to require them to have training, and whether that is at your cost or whether it's at their cost. It's not a statutory requirement, but it's a really good idea to have an extra clause if you are going to be investing any significant amount of money in an employee's training, to claw it back, a repayment of training costs clause. It would normally have a sliding scale. So, maybe for the first year, it would be 100% of that cost, and then going down maybe in 25% increments. But it is a good idea if you are, paying for an expensive qualification, to have that within the contract. then I mentioned earlier that there are other things that you have to provide, but they can be in other documents, and you've essentially still got 2 months to provide them. So these are terms relating to pension schemes, any collective agreements affecting the contract. And a collective agreement is if your business is, if you recognise a trade union. So it's the collective bargaining arrangements. Any training that you're going to provide, and disciplinary and grievance procedures, including any appeal. So the documents to look up for disciplinary and grievance are, if you search the ACAS website, there's something called the ACAS Code of Practice, and that is essentially what you need to follow if you were to carry out a disciplinary procedure, or if an employee wanted to raise a grievance, a formal grievance with the employer. And it's really important that you make sure you comply with the ACAS Code of Practice, because if you don't, the penalty that might be awarded if there were to be a tribunal claim can be increased by 25%. So any financial award can be increased by 25% if an employer unreasonably failed to follow the ACAS Code of Practice. It's really important that you have, if you only have 2 policies, make them disciplinary and grievance, is my advice. And then just a few other considerations with contracts, just to make sure that you are always keeping an eye on and complying with the national minimum and the national living wage, making sure that you are aware of and complying with working time regulations, bearing in mind working time and travel. So if an employee is a home-based worker, for example, and they travel from their home to their first appointment, or from their last appointment home, that is considered to be working time under the working time regulations. Now, it doesn't necessarily have to be paid time, but it does count for rest breaks. You would have to make sure it's paid if it would mean that they're going to fall below the minimum wage, but if they're on a really healthy salary, you don't have to sort of pay extra for that time. It can be included within their salary. Holiday pay, I mentioned earlier. So if overtime and commission are going to be part of the regular arrangement with the employee, you need to keep an eye on that, because it's going to be really important when it comes to calculating holiday pay, which I mentioned earlier. And continuity of service, essentially from day one, continuity of service begins to accrue. And there's a bit of a myth that you can sack anybody in the first 2 years of employment, and that really isn't true. So I would urge you to just be aware that you need to have 2 years service to be able to bring an ordinary unfair dismissal claim, but there is a whole host of other claims that an employee can make from day one, and also unfair dismissal where there is sort of added element of maybe discrimination, for example, or maybe where an employee is a whistleblower. All of those sort of claims have added protection, and they don't need 2 years service. So just always keep that in mind, because the frequency in which we hear, oh, they've got less than 2 years, it's not a problem. Well, it is a problem. And besides which, it's really important as employers that, we're acting in an ethical and moral way, and that we're treating people well. People are often our biggest commodity. Then we come on to other documents to have in place in terms of your legal compliance to be recruitment ready. So alongside your contract of employment, you should have a privacy notice, which is just a bit of an overview of all of the data that you might process in relation to that employee. And in order to come up with that privacy notice, you should really be carrying out a data audit. You should have a data register, which is essentially a great big table of saying these are the documents that we're going to process on employees. This is who's going to have access to them. This is where we're going to store them. This is what we're using them for. This is how long we will keep them before they're destroyed. So it's basically a big register of all of your sort of employee data in terms of data processing. And if it is more sensitive data, you should really be carrying out a privacy impact assessment as well, which is a bit of a risk assessment on the data. So that might be appropriate if, for example, you have company vehicles and you have trackers, then that would be, something that I would expect there to be a privacy impact assessment. Or if you have CCTV in your premises, for example, or if you are going to have the ability to monitor telephone calls or emails, internet usage, it's a good idea to carry out a privacy impact assessment on that activity and to then make sure that it's included in any related policies and certainly made known to the employee in the privacy notice. So I also really advise that you invest in a handbook and HR policies. Sometimes they can all be part of one longer document, but more and more often we find these days that companies will have an overview handbook, which is kind of really nice because you can brand it. It can be very much in your own language. It can be quite upbeat. And then lots of associated policies that are standalone that run alongside, because really, unless somebody is thinking of adopting, they don't particularly want to have to scroll through a really long adoption procedure or policy. Whereas if they are thinking about adopting, then certainly they're going to want to read the policy in full. So by having a little overview handbook, you can have a list of associated policies at the end, so that employees are aware of where to get that more detailed information if they need it. And there are so many policies that you can have, but the ones that I really strongly recommend to any business from day one are data protection, equal opportunities, diversity and inclusion, disciplinary and grievance. If you were only to have 4, they would be my top picks, but there are so many more policies to have. And they're really helpful for you as an employer as well, because they're almost a step-by-step guide to how to handle a situation when it comes up. So that was everything in terms of your sort of documents to have in place. So I've just got a bit of a slide really to finish off on, which is and everything else. And this
excellent, that's fab.
Processes to implement. If you think about your employee journey from start to finish, hopefully it's going to be a really long relationship. And this and everything else sort of list, it's not exhaustive by any means, but I've just kind of put out there all of the sort of extra things to think about if you're going to have employees. So things like shared values. Really great to have sort of shared values in place, and really great if you can include your employees in deciding what those values are. HR software, so where are you going to record things like holidays, things like absence, next of kin details, employees' home address, and there's loads of different HR software out there. One that we particularly like is called Breathe HR. For example, probation we've covered, flexible working. So I mentioned earlier about home workers or hybrid working, but actually what about ad hoc flexible working? If they got the opportunity to work a little bit earlier one day or work a little bit later or work from home on an ad hoc basis, thinking about what those arrangements will be. How are you going to manage absence? Are you going to have return to work interviews or sort of self-certification forms? And things like that. Breathe is not free for small businesses, but the starting point on it is something like £11 a month. So it's not it's not hugely expensive. It's one of the more cost-effective ones out there, actually. And I believe, no, I don't believe, I know that if you were to trial Breathe from the 1st of December, they're offering 3 months at half price after the month trial. Then you've got things like well-being. So I mentioned earlier about putting in the contract if you've got an employee assistance program. They're really cost effective and such a useful tool where employees have got access to a free confidential line if they want to chat about personal challenges that they're having. Maybe they're going through a relationship breakup, maybe there are financial difficulties that they're experiencing, maybe they're going through bereavement. It's just a really nice extra support to sort of provide them with. So think about well-being, training and development. How are you going to sort of support their continuous professional development? Events, are you going to have an annual Christmas party? HR nightmare. Please be careful with where you go and how much alcohol is consumed, because you can imagine for us in HR, January is a very busy month sorting it all out. How are you going to communicate with your employees in terms of things like one-to-ones? How are you going to give them continuous feedback? Are you going to do appraisals? How will you progress them in the organisation? And right through to exit. Are you going to do an exit interview? Because that's a really good way. If you record an exit interview over time, hopefully you don't get loads of employees that are leaving, but over time it gives you the opportunity to monitor for trends and see if there is anything that you need to kind of be aware of and maybe make changes in response to. And then finally, references. I just wanted to mention that if you have an employee that leaves your business and you receive a reference request, make sure that you don't just provide it because of data protection. You need to make sure that whoever is requesting it provides you with the signed consent so that you can be confident that you're giving a reference and that the employee is aware and has requested that.
Amazing.
So that was a bit of a run through. I hope your head.
That was fantastic. Absolutely incredible. Thank you, Kate. That was fantastic. Obviously, we've got quite a few questions that have come through in the chat, but again, just to sort of circle back around to the fact that we are quite a small group. If anybody wants to come off mute and obviously ask a question to Kate, then please obviously feel free to do so. We've got a couple of more minutes left on the webinar for you to do that. Oh, Laura, you.
I just wanted to say thank you for answering all of my questions. Oh. So there were quite a few sort of as we were going along there. We were in the middle of sort of updating a lot of our contracts and things. So for us, it's more just around the continuous employment more than anything. And that certainly helped. So we should be able to crack on with updating those now. So thank you.
Oh, amazing. Oh, that's great feedback. Thank you, Laura. That's fantastic. That's exactly what we aim to do, is to give you some practical advice. So yeah, okay, excellent, fantastic. Okay then, well, I think if there aren't any questions, we could probably bring this to a close, I should imagine. Kate, again, thank you massively for your contribution today. Fantastic. And I'm not sure is it okay? Oh, sorry, Louisa has a question.
Hi, can you hear me?
Yes, very faint, but yes.
Okay. What I want to understand is about the casual workers. We run a farm and we have people, for example, who come pumpkin picking, and they may come for a 3-hour shift and then we don't see them again. Do we still have to provide them with a contract? Because we have contracts in place for our permanent staff, and I think the written statement of terms is about 10 pages long.
Yes.
And then we have obviously a handbook which is probably 50 pages long.
Yes. So the short answer to that is yes, you do, because the law has now changed and it became a day one right. However, I would not suggest that you give them the same document as you're giving to your employees. And I should just say that is the exact perfect example of where 0 hours casual work, because that is what is intended for. Things like pumpkin picking, perfect. But what I would advise is that you set out the written particulars for the casual worker in more of a letter format. So it might be a 2-page document instead of 10, but they still do have to have those things in writing particular to them.
Okay. And if somebody turns up and says, I don't want to give you my home address, and they don't want, are we still meant to have their what's the word, their passport and all that sort of thing, some sort of identification? Because we had one person this year who told me he lived off grid.
Yeah.
I mean, what do you do in those sorts of situations? Do you send them away?
Yeah, unfortunately, you know, you wouldn't be legally compliant. So unfortunately, in those circumstances, it would be very difficult. You don't have to put the home address
right
in an agreement. There is no legal requirement for their home address, but you do have to check that they have the right to work in the UK.
So we need to have that passport for every single person that comes to work.
Yeah.
Because what are the, I suppose there could possibly be some form of sanction, could they, Kate, if obviously you're caught?
Yeah, it would be more if it goes wrong. Things are never a problem until they're a problem. So if you inadvertently employed somebody who didn't have to work in the UK, and you know, that was discovered, then that's when it really is going to be a big problem.
Okay, yeah, makes sense.
Is there anywhere a template for this sort of letter, or is this something we need to get drawn up for us for the future?
You could have a look. ACAS is always a really good starting point. And Sue, and I don't know whether Business Wales.
Yeah, so I should imagine so, Kate. Yeah, you're absolutely right. Yeah, so there's probably some additional resources available on the Business Wales website.
Right. Okay, thank you.
That's great. Fabulous. Thank you for your question, Louisa. That's lovely. Thank you.
Thank you.
Okay, fantastic. Well, I think